Peace. What's going on? Good morning. Good afternoon. In another minute or two. Um, I wanted to have a in-depth discussion about what's actually going on when we're receiving traffic citations and also criminal complaints in the court systems. And this should help people. First, what's more important is gain an understanding of exactly what's going on and what's happening behind the scenes. So to get to it, it's really hard to do this because you're dealing with the understanding of people who have different understandings of law. I might be coming to you, and this might be your first time hearing of this, and then of course there's a lot of people that's on Facebook that are actually diligently studying law. So I don't know. I might speak ahead of you. If I am, don't be afraid to just say, please clarify that, something like that. This is not a forum for embarrassment. This is for enlightening, teaching, and making people more aware and being able to function in their own capacity. So it's a teaching forum. So don't get thrown off and think someone's here to belittle or badger you. That's not the intent at all. So I'm gonna go ahead and get into it. If you're not familiar with this, again, if you have your phones or a computer, you're near one, or at a later time, you can look this up. It's available as PDF. It's actually available through government websites. One is Cornell Law School, which I like to use a lot, and it's available here for us. It's for the public. We're supposed to have access to this. All right, so starting out. So when you get pulled over, a lot of times what they're not informing you is that once those lights go on, those lights are activated, that is considered to be an arrest. You are detained. Because I see a lot of videos where people are asking, am I detained? Am I free to go? I think that's more suitable in a situation where you're being stopped and you're on foot as a passenger or something like that. At that point, you may want to ask, am I being detained? Can I leave? But when an officer and you're in a vehicle and he's in his and he pulls you over, when he activates those lights, you are being detained. That is a investigative stop, and you are detained. You are not free to leave at that point until the officer says otherwise. Also, and again, like I keep stressing this word, you are under arrest. When those lights go on, an arrest is made. It actually signals back dispatches to the precinct, and at that point, if that officer did not arrest you physically, he has to have paperwork and clarify for why, because his lights were activated. So it's the same as if you were to call in 911 and hang up. 911 is going to call you back because they're assuming that there was a crime being committed, and maybe the person had a chance to grab their phone and call in, and maybe you grabbed the phone from them, slammed it down, or broke it or something. So they're looking to, they're going to actively pursue, and they're going to keep that line open. Sometimes you can actually see something blinking on your phone that's saying 911, letting you know that it's a beacon for your location. And they'll actively try to call you back and get you on the phone until you can say this was an accident or we need help or whatever the situation may be. All right. So what happens at that point? Once you're pulled over, you're detained, you are under arrest. You are never Mirandaized. That is part of being arrested. Is they have to inform you that you have the right to remain silent. Anything you say can and will be used against you in the court of law. So whenever there is not there's an arrest and there's not Mirandaized going on, basically it makes any statements, any evidence produced inadmissible. Because if you get pulled over and the officer is communicating with you and you're responding very responsive to the officer, and you're incriminating yourself, it's just like with any other thing as far as like laws, as far as recording people. You have to have people's permission to record. If you record without their permission, it's inadmissible, and it's actually in some sense a crime that you're committing. So for you to produce evidence of a conversation or anything, transaction that you have with someone else, thinking that you're going to use that for your case, you could actually incriminate yourself and expose yourself to either criminal or civil um, ramifications. All right, so just moving forward. Sorry. So basically, say whatever happens, you were speeding, you didn't have your seatbelt, you made a right turn without your signal, or whatever the case may have been, and he issues you a citation. And this is what I want to get into. That citation, what people aren't being told and being misled. So that comes in the form of misrepresentation, that's fraud in the inducement. It's a lot of things that they're not telling, because you have to have all your decisions have to be intelligently and knowingly, and you can't make an intelligent or knowing decision if you don't have all the facts. So the first thing that they get you to do, and I found this in the laws. I went in my state in the laws and I found it. And it doesn't mean because it's on the books in this law that, all right, that's it. That's the finality of it. No, it's not. In their laws, their statutes, they wrote that an officer has to have your signature. And what the signature is supposed to recognize is that you recognize that you are required to appear into a court, and that you promise to appear on your own recognizance. So that's how they're releasing you. It's called release on your own recognizance, and that you promise to appear. So when you do not appear, that's basically it's a breach of contract, which is it's a common law claim. So the whole thing that we're not understanding is that it is a lawsuit. That citation that you're issued, again, what is not being told is that it's a contract one. It's also a negotiable instrument. This is something, all right, I'm not even going to just keep saying that. It's whatever. You guys have computers, you have phones. I hope that if there's something that you understand, you don't understand, just look it up. If there's something you don't understand, you want to ask me, just ask on the post. Somebody there is probably willing to help you and help you along with that. But these citations are negotiable instruments, and they have a monetary value to them. So you could, not you per se, but they have the ability of trustees, receivers, stuff like that, to take these and monetize them. And so I posted a picture earlier, and I went into the site, and this is something I'm starting to research and deal with on a regular now, is their financials, because they generate revenue. And I'm trying to think, for the most part, I think they are for-profit corporations, government entities, government agencies. So you ask, all right, they really don't do anything. What do they do to earn money? What do they build? What do they make? They don't. So you would have to sit there and say, wait a minute. So they built revenue, or they did 460 million in revenue last year, or whatever the case may have been. You're looking at their numbers. Numbers are incredible. So you have to understand that this is not funding that's given to them by the federal government, as we're led to believe, that the federal government makes out the budget and then it disperses money to the states for what the states need to operate. That is not the case at all. The states are independent agencies that raise their own capital, their own revenue. All right, so for that part, so you have the citation is given to you, you sign for it. That is the commencement of a lawsuit. And that lawsuit will eventually be for a breach of contract, that you've breached the terms of that contract that were not revealed to you. So so basically it goes out just like any other lawsuit. And I'm going to go into that. I'm going to start talking about that actually right now. All right, so you have what's called the Federal Rules of Civil Procedure. And this governs pretty much all lawsuits. You also have the Federal Rules of Criminal Procedure, which for the most part, I think I've heard this before, and I always like to go now on my own research and own understanding, is that they say that there is no criminal. There is no criminal jurisdiction, any of that. And you can find that right here in Federal Rules of Civil Procedure. It's Rule 2. And I think, it's very brief. So it's very brief. A lot of times what these courts and judges, attorneys like to say about us is that we're misinterpreting and making up our own understanding of the law, and that we're not qualified to interpret law. So I'm going to read it for you. It's very brief. I don't see how a 12-year-old could misinterpret this. Morning, Kenyatta. Um, all right, so yeah, here it goes. So it's Federal Rules of Civil Procedure, Rule 2, one form of action. So an action is something that you bring forth to the court. So it says there is one form of action, the civil action. That's it. End of the rule. There's nothing there to be taken out of context or anything like that. There's some other things, and I like it's more of an annotated form. So it just says notes. So I'm going to read a little into the notes for you. It says this rule modifies United States Code Title 28, former 384, suits and equity when not sustainable. And it says conferring power on the Supreme Court to make rules of practice and equity are unaffected insofar as they relate to the rulemaking power and admiralty. These sections, together with Section 723B, C20, it's saying C as citing 2072 rules and actions at law Supreme Court authorized to make, are continued insofar as they are not inconsistent with 723C, Union of Equity and Action at Law Rules Power of Supreme Court. See Note 3 to Rule 1, United States Code Title 28, former 724, Conformity Act, amendments to pleadings when case brought to wrong side of court, and 398, equitable defenses and equitable relief and actions at law are superseded. And it says reference to actions at law or suits and equity or all statutes should now be treated as referring to the civil action prescribed in these rules. So it's basically saying right there that, and it's speaking of admiralty is what they're operating in. They'll tell you that it's statutory, but it's actually admiralty. So it tells you there's no criminal. There is no criminal form of action. So I'm going to go back to it. So remember, we just discussed the traffic citation. This traffic citation is what's called a charging instrument. It is the same if you look in a lot of the constitutions and you look in law. It says that there can only be a conviction upon information, presentment, or indictment to a grand jury. So a citation is considered to be an information that is filed. A prosecutor can either file that under oath, or an officer of the court can also file it, which would be a police officer, policy enforcer. All right, so I'm tying this together, and I just want you to follow along. That's why I'm doing so much extra talking. Most people say that you're giving too much information, but I'm giving so much so that you can see how everything fits together. So it says Title 2. It says commencing an action, service of process, pleadings, motions, and orders. So Rule 3 is commencing an action, and that's what was done when you were given a citation, that you were being charged with someone's making a claim, basically. So let me go into it. Hopefully this is brief. All right, it says Rule 3, commencing an action. A civil action is commenced by filing a complaint with the court. So that's what we were just discussing. That complaint is the ticket, the charging instrument. I'm going to give you another freebie to help you with a lot of your cases. I haven't been as lucky and fortunate yet, but there's a 5-day rule where the officer, when he issues these citations, he has 5 days to deposit these with the clerk of the court, mostly through electronic form, because most tickets are given in electronic form unless you're in some, state that is really small or just has like a really small jurisdiction or something like that, and they're still actually using the book with the flip tickets. But most of them are done on their laptops. They're electronic, and they submit them electronically. So it says the civil action is commenced by filing a complaint with the court. It says Rule 5E defines what constitutes filing with the court. This rule governs the commencement of all actions, including those brought by or against the United States or an office or agency thereof, regardless of whether service is to be made personally, pursuant to Rule 4D, or otherwise pursuant to Rule 4E. So service is always made right there at the stop. The officer will have you sign a ticket, And in most cases now, they are taking a thumbprint from the offender, and so that's considered service. And that's proof of service when he gets your signature or your thumbprint or thumbprint. So after that, go to the next step. And I want you to see, like, hopefully if you're reading and you have your computer and you have access to the Federal Rules of Procedure and you're following, or if you read this later and look at it and see how it ties together. Next comes the summons. The summons is mailed out by the court, reminding you that you have a court date, that you made a promise to appear, and failure to appear will result in a default. This is a default judgment against you, and then whatever sanctions were going to be carried out will be carried out in your absence if you don't appear. So that's the summons. And it's funny that, like, I really didn't put this together sooner, because I read all this stuff, I study this, and I've always gotten the summons from the court, and now I've gotten more into the lawsuit side. So I'm reading, and I have to actually type out or fill out my summons and have them taken to the clerk of court and have him put his stamp and seal on it. And so now everything's clicking because I'm actually doing this. So when I look back at this process of what it is, it helps me to understand how to defend it, how to properly move before the court. I see a lot of remedies that so-called remedies that people are advising people to do, and I really don't see a lot of remedy in it. To go in the court to challenge the jurisdiction, all they do is enter a plea for you anyway, and even with your objection, you can object to it. The judge still gonna enter a plea on your behalf. They have business to carry. It's called the business of the court. So that doesn't work. Trying to defend the Constitution, that doesn't work. It doesn't work effectively. I'm not saying that there are not people out here who are doing it, but you want to go in consistently and have the same results. So what better way than to understand what exactly is happening? You're being sued. The state of so-and-so is suing you. They're the plaintiff, you're the defendant, you're defending the action. The only thing we have in our best interest is that the burden of proof is always on those bringing the claim, which would be the plaintiff. And that is by the preponderance of evidence. By the preponderance of the evidence, they have to prove every element of the claim that they're charging you with. Exactly. And I'm talking from personal experience. I'm not just talking about from watching the videos and stuff like this. I've been in the court. I have had some success, not as much as I think I should for the amount that I study and the amount of things that I know. So, sometimes this is what causes you to be creative and come up with your own process. It's not always about trusting what somebody else is doing and just taking their work or their template and their affidavit and written, putting it together and filing it in court. That's really not going to always get you what you want. But this right here, I see as a viable source. All right, so I've discussed the summons. So you go to Rule 4.1, and that's why I hate. Sometimes I want to read just the ones that are quick and fast. This one's not too long, but it says serving other process. In general, process other than a summons under Rule 4 or a subpoena under Rule 45 must be served by a United States Marshal. All right, so this is more so talking about more federal courts when you would use a U.S. Marshal to serve as summons. So it's a little different. The federal rules of civil procedure do apply to the local state courts, and I have my Florida rules of civil procedure right here too. So you will find the same thing. They mirror each other. The rule numbers are going to change, but the same headings. Like what I just read you earlier, one form of action is still right here. It says when action is commenced. So let me go back. The word is just different. So this is Rule 3. It says commencing the action. This one says when action commenced. It's the same thing. But I don't want to throw you off too much. So let me go back. You got that. You got the summons. You got the serving of process. You got serving, filing pleadings with other papers. So that's all your pretrial stuff as that's when you want to file, ask for discovery. Once you get your discovery, that's when I would recommend filing any motions, because you want to know what type of motions to file, and you can't do that until you understand what type of evidence they have against you. And a lot of times, they don't have a lot of evidence, and it depends on your ability to be able to read into your discovery. The stuff that they do present you with is what you can use to tear your case apart. This has recently happened to me, where sometimes even when I think someone else might have looked at discovery that was sent to me and said, "Damn, they got me. That's it." Unfortunately, or fortunately, I do a lot of studying, and exactly, Kenyatta, and when I looked in there, I don't give up easy. I just kept looking, and comparing different sources. I'll go to the read the local whatchamacallit, Constitution, and the Constitution. Sorry about that. Putting a little essential oils in my locks, if that's what you want to call them. I mean, they're not, hair's not locked up, but that's what you would refer to your locks. Put a little on the beard, get that going, and gets you energized and kind of wakes you up. And it's geranium. So geranium, essential oils, and smells pretty good. It's real revitalizing. This one here, I got a little lavender left. That was a sample that they gave me. I bought me a diffuser, so it's pretty good. All right, but not to get too sidetracked. I'm just used to Jonah Bey doing that. Jonah always gives you a little bit of everything. But all right. So get back on path. All right. So it says serving. Yeah. So basically, that's what's gonna happen. You're gonna initially what you want to do in your first court appearance is you definitely want to go and direct this to the prosecutor. If you're in a municipal court, there probably isn't going to be a prosecutor. You have to actually write to your county attorney. They say the state or county, or county attorney, and you want to ask for your discovery. They may give you a hard time. They try to mislead you, and that's why I said the rules are important. If you want to go in your local, your state rules, and get these books, you can go on Amazon or eBay, and they're pretty cheap. I want to say, excuse me, at first when I show you this book, I have a whole bunch of markers and papers in there that's marking certain things that I had reviewing, but just wanted to show you the book. So this is the Florida Rules of Court, and like I said, once courts are done with them, they either donate them or they sell them really cheaply just to get money to offset for paying for the new books, because they get new books every year. They have to have the most current ones, because it has case law in there to help you. Some cases that were still tied up in whatever court they were in, Supreme Court or the District Court of Appeals or wherever they were. Most of those cases, sometimes they don't have a citation until they're actually printed and the publication. So it might have been pending, or it might have been decided in the previous year. But when you get the new book, more than likely it'll be in there. So that's why they try to stay current with getting the current books. But any book will do. So basically, let me keep moving along. It says commencing action. It says serving papers. All right, so this is a really important one, and this one here is different. Like I said, they differ from each other, but they mirror each other. Some of the wording is always the same, and then sometimes you'll have better protection. There might be something that you're looking to express that is more expressed in the federal rules of civil procedure than it is in your state. But again, you always want to start with your states, because you want to start in state court. So you get in the state court, you're going to follow the state court rules. Yeah, get discovery, and then you tear it apart. Now, this is the part where you get to have, participate in discovery. And this is what a lot of people don't do. as well, because they don't understand that it's a lawsuit going on. Once you grab that, understand that it's a lawsuit, and you can interact and understand that it's not just going up there, it's not playing, it's not spewing a whole lot of rhetoric, which they're calling sovereign citizen theory right now. At that point, not saying anything good or bad against it, but yeah, they're going to classify you. They're going to put you on a private list that says that you're associated with a sovereign citizen group movement, and in a sense, I personally don't see any difference with it, because we're classified as that anyway, regardless of that case. But you're just on an extra special list at that point. So it is what it is, man. So here, this is a very important one. This is Federal Rules of Civil Procedure 5.1, constitutional challenge to a statute. And notice has to be given. Notice is very important. Notice always has to be given in any lawsuit. If there is not notice, you can't sue someone, not tell them they're being sued, and expect to prevail in court. You'll actually, the court won't tell you. Most times they won't. They will let your case sit there until the statute of limitations has ran, and you will get what's called a failure to prosecute, and they will dismiss it. So you must always give anyone notice of anything. So that's called notice, and it's certification to either the state attorney general or the U.S. attorney general, and intervention by either the state attorney general or the U.S. attorney general. They're not obligated to intervene, but you have to give them notice and the ability to intervene if they feel so. So that same rule is also here in the States, but it's different. I like how it's worded. I mean, and I just lost the page. Oh man! All right, where'd I go? Here it goes. Because I actually got that page bookmarked. All right, so this is under Florida Rules of Civil Procedure, Rule 1.071. Constitutional challenge to a state statute or county or municipal charter. You can actually declare the whole charter of the city unconstitutional. And you can challenge any ordinance or franchise. And then again, as I just said, notice by party. You must give notice. Notice is always given. If you file something with the court and you fail to give notice to the prosecuting attorney, then you basically wasted your filing, especially if you put exhibits and all this stuff in there like that. It's cool, yeah, you put the court on notice, but the defending party, because all parties to an action has to be given notice. So when you're suing, this is something that you might want to realize, because over the years, I've always, when you're doing research, you'll see cases where people have like 15, 10, 30 defendants. That could be very expensive. Most times, these are law firms doing this when they have a solid case. You have to pay to serve all of these defendants individually, even if they're all part of the same corporation and they're all in the same building. You have to serve each one individually, and it's going to start hitting your pockets. There is a way around that. I've seen it before. I guess I didn't read it thoroughly enough until I actually had to go and serve some people and realize the cost. And like I said, 3 of them, one was just an assumed name of the other, and then the other was an employee of the same company. So my understanding, I'm like, all right, they're all right there. They're in the same building, the same place. It's the same action. I thought I could get by with just putting everything in one envelope and just shooting it. And apparently that's how the service or process companies make their money, is they're going to charge you each defendant individually. And also what you have to be careful too is when suing multiple parties like that, if your claim is not rock solid, you didn't put your pleading together right, and it's dismissed for failure to make a claim upon which relief can be granted, they will come back and ask the court to grant attorney's fees, which is in a sense, only rightfully so. You brought them into an action where they had to get an attorney to defend. Why should they be stuck with the bill when you didn't bring the claim properly? So they will sue you for attorney's fees, and you can get drowned in a lot of debt. Lot. Like, depending on what these lawyers are billing per hour and how many billable hours that they bring forward to the court per defendant that you sue. So be very careful with that. Sometimes it's in repetition. You don't need to sue every entity of the company. You just go all the way up the highest part of the line and sue them, because they're obligated and responsible for all the rest of them. So that's something you want to do. And when you're suing people, you also want to make sure that you do so in their individual and professional capacity. So that's the difference too. All right, so what was I going to? All right, so that was that. And it says notice by party. I was talking about that. So it says, all right, this is subsection A of that, the constitutional challenge to a state statute or a county. It says, file a notice of constitutional question stating the question, identifying the paper that raises it. It took me a lot of time in the beginning when I was reading that. I couldn't understand. I thought I had to actually ask a question. And I'm like, what it says? It says, and then file the identifying the paper that raises it. And sometimes this is just by citing the paper. But also when doing mines, I like to actually take a certified copy or authenticated copy of the actual statute or charter that you're attacking, and including that with it. So this is just being tight, just tightening your stuff up. All right, so next you have pleadings and motions, and I think this is what we were just talking about. So after you've received discovery and after you've had a chance to participate in discovery, bringing forth any exhibits or attachments or anything that you want to include in discovery, anything that you're going to bring up in your defense and talk about, you have to enter it and what do they call it? Participate in discovery. If you don't, it's considered to be waived. It's considered your right to add things to discovery was just waived. You didn't want to participate in it. That's not a good thing. Especially if whatever party has discovery and other one doesn't, then anything that they state at that point is basically accepted as true. And especially if you don't make an objection to it in any way, or a counterclaim or anything, defenses, objections. So that's what we're getting into next. It says Title 3, Pleadings and Motions. Pleadings allow form of motions and other pages. That's Rule 7. I know it's going to be pretty long. I know y'all don't want to hear all that. It's not too bad, but if you're here to learn, man, this is what it is. Rule 7, pleadings allow form of motions and other papers. Pleadings, only these pleadings are allowed. A complaint. So again, the traffic ticket is the complaint. It says an answer to a complaint. So that would be you responding to the complaint. An answer to a counterclaim designated as a counterclaim. So in your heading, you would definitely let it be known that you're giving notice that this is a counterclaim. And then the respondent can have an answer to a counterclaim. And then there's a third-party complaint, someone who's completely, trying to say the word, third party. So I guess a third party would be someone if you destroyed their property, because the state of whoever is bringing the claim, but a third-party complaint would actually be the victim or witness. And then it says an answer to a third-party complaint, because of course you would get to reply to that again. And it says if the court orders one, a reply to an answer. If they need further, if they need just further evidence or information, they would the court would order you to reply to that answer. And then it says subsection B, motions and other papers. In general, a request for a court order must be made by motion. The motion must be in writing unless made during a hearing or trial, which means that you can make a what do you call it? I don't know if you want to call it verbal motion. Yeah, I guess you can call it that for lack of better words. It says state with particularity the grounds for seeking the order and state the relief sought. So these are some things I never really understood when I was putting together drafts and pleadings that I have a complete understanding of now from being in the practice of it and then getting orders back from the court instructing you to comply with the rules of the court. They will ask you and they expect you to do this, regardless if you are represented by an attorney or not. They feel that it's not fair that if you're going to come into their arena and not abide by their rules. So this is a lot of things that we're being taught to only use the Constitution, don't use their rules or codes. You are not going to get your remedy by coming into the court and not using the proper form and being in the proper time for filing certain things. There's a time for them, and sometimes you need leave of the court to do certain things. All right, so it says definitely, yeah, you got to state your relief sought. Whether it's monetary, you have to express how much, and your grounds. Most people just think it's just a motion. You put it and title it and put your heading, and that's it, and you're done. That's not the case. And it says form. The rules governing captions and other matters of form and pleadings apply to motions and other papers. So yes, it has to be the same on all of them. Some people think that just your first page has to be this way. And then like other motions or other affidavits following doesn't have to be that way. So usually what I do is I save a lot of my work, and I'll just go back in and copy paste the whole heading caption from the top and then bring that into a new one, change the heading, and then draft from there. So that way you don't go wrong. Only way you can go wrong is if you're dealing with a couple different cases similar to me. I tend to grab something, leave the case number the same as when I grabbed it, and I needed to change it to reflect a different case. So that's something you want to be careful for, and you want to actually just look over before you file it, because you'll notice some errors. Sometimes I do that, and I wasted a whole ream of paper, and I was pretty mad about that. It's some good paper. I actually got I think it's the 28 pound as far as the weight of the paper, and I like that because it feels better, especially when you're moving paper and filing documents. The 20 pound is just not enough. It's really light. It's it's just, I don't know. It's just not good for doing what I'm doing. So the 28 pound, you can feel it. It's a lot heavier. This is some stuff that I got from the court, and it's on good paper. Yeah, you could feel the difference. I think this is something that I printed previously, and it's on just 20 weight paper, so it's not that good. And what else do we have? So we have form pleadings, we have signings, pleadings, motions, other papers, representations for the court. You have defenses and objections. A lot of times we don't present our defenses. Like I said, a lot of times these YouTube videos and different things have us using these strategies that don't conform with the rules and the procedures. And I think I'm getting away from that now. This is all you have to do is follow. This is a template. So you, after getting your discovery, reading through it, studying it, eliminating, finding your points where you're going to attack it, where there's holes or where they didn't prove their case by preponderance of evidence, you could actually submit a motion to dismiss under Rule 12B. And there's a couple other subsections of that, I think, but most of the times it's 6 for failure to state a claim upon which relief can be granted. And where was I again? So counterclaims. There's a lot of things that you have to file. Let me see. And there's timetables for these. A lot of times when you file things, there's a time that you have to file them. Also, there's a time for response. So if you don't get a response at a certain time, you want to notice the court and also give notice to the party who didn't respond. Let me see. Joinder of claims, sometimes they could cite you for multiple things, but if you look, there's called lesser included offenses, and they may actually stagger those out so they can increase the fines or the penalty for the time or whatever the case may be if it's a criminal action. So you want to look for that, and you can ask the court by motion. Everything is a motion. When I say ask the court, is to join the claims together, um, or to exclude parties. Sometimes they bundle all these parties up, people who had nothing to do with something, and just got caught up in the wrong place, and they make all of you tied up and bring you into a conspiracy charge, which is very hard to get out of. But through affidavits, you could actually write an affidavit if you want to dismiss someone from an action that they had nothing to do with. You can actually do that if you want to be honorable. Let me see. All right, so we move to the next part. So this is talking about discovery. We were just talking about that. It says duty to disclose. It's Rule 26. So they do have a duty to disclose it, and there's a timetable for doing so. And then there's dispositions, which happens during pre-trial, is where you and the plaintiff are trying to work things out and see if a trial is still necessary at that point. Because they'd rather forego trials. It's very time consuming. It ties up the resources of the court. It could be very expensive, and it could expose you to how you say it, just expose you to more penalties or fines or things like that. So you have interrogatories that you can file, which is questions that you would like for the party to answer. You can file those. Let me see. And then you can request certain documents that are electronically stored, tangible things, entering into land if you're talking about a land tenant, case, or if you're talking about a foreclosure or anything like that. Yes, you can ask for inspection of the property or something like that. If you're suing for mold or something like that, whatever the case. Let me see. Request for admission, failure to make disclosures. Yeah, this is right here. Rule 37. It's a lot here. I'm not going to read all this. I'll probably just hit on some of the subsection points. So let me go back to the top. All right, it says failure to make disclosures or to cooperate in discovery and sanctions. So you can definitely be sanctioned for that. So it says motion for an order compelling discovery or disclosure or discovery. So that's a great motion to use. It says on notice to other parties and all affected persons, a party may move for an order compelling disclosure and discovery. The motion must include a certification that a movement has in good faith conferred or attempted to confer with the person or party failing to make disclosure or discovery in an effort to obtain it without court action. So that is just what I said previously, is that you want to contact them after the time has expired or elapsed and ask, hey, I asked for discovery or I asked for this document, I failed to receive it, and see if that'll move them to do it. And if not, you can get the court to actually do it. The court is going to, that's what it said, the motion must include a certification that you've already tried in good faith to obtain these things on your own. So it says specific motions, a compelled disclosure. If a party fails to make a disclosure required by 26A, any other party may move to compel disclosure and for appropriate sanctions. So you can have that person sanctioned so that they'll be on notice that they probably won't withhold anything upon your request again. And let me see. And yeah, just failure to comply with a court order. What else is down here? Dismissing the action, holding part. Oh, the sanctions. Sanctions for not obeying a discovery order. Damn, I like this. It says if a party or a party's officer, director, or manager, agent, or a witness designated under Rule 30B6 or 31A4 fails to obey an order to provide or permit discovery, including an order under Rule 26F, 35, or 37A, the court where the action is pending may further issue just orders. They may include the following: directing that the matters embraced in the order or other designated facts be taken as established for purposes of the action as the prevailing party claims, prohibiting the disobedient party from supporting or opposing designated claims or defenses or from introducing designated matters and evidence, striking pleadings in whole and part, staying further proceedings until the order is obeyed, dismissing the action or proceeding in whole in part. So that's what you want, and that's remedy, and and that's what this is remedy just by their own rules. You know, a lot of people are sending people in court on some wild stuff, man, and I'm not seeing enough evidence of it actually, just working. And it says treating the contempt of court, the failure to obey any order except in order to submit to a physical or mental examination. For not producing a person for examination if a party fails to comply with an order under Rule 35A requiring it to produce another party for examination, the court may issue any of the orders listed above, unless the disobedient party shows it cannot produce the other person. This one, I just hit a gold nugget live on camera. What was that again? That was, yeah, it is Rule 30. So 37, and what was that? Trying to see which, damn, trying to find it again. The party found admit had a reasonable ground for bail. Oh, right here. All right, so it's 37. It's confusing. All right, so it's 37. Failure to comply with a court order, which is B, lowercase b, and then it moves down to subsection 2B, capital B, for not producing a person for examination. And it says they fail to produce them, the court can dismiss it. So you can actually ask for the state of whoever it is, the state of New Jersey, the state of Florida, the state of Texas, New York, to produce the state of Florida, state of New York. And if they cannot produce them, move for dismissal. And it says failure to disclose, supplement early response, or to admit. All right, let me see. I'm gonna try to wrap it up soon. I see it's at 44 minutes. Try to just, if best, do this for an hour. All right, so this is so then it moves to trials and right to jury trial demand. And in most cases now, what I'm noticing in the states is they won't give you a jury trial in a municipal setting. Anything that doesn't promise the incarceration, they will not give you a jury trial. They won't spend the money. They won't put the people together and stuff like that for you. So this is trial by jury or by the court, which you can have what is called a judge trial or a bench trial or a non-jury trial. So let me see. So there's a lot. Let me see. Just want to read this one. This one caught my eye. Dismissal of actions. So there are many ways that a action can be dismissed. One is under Rule 41A, voluntary dismissal by the plaintiff without a court order. The plaintiff may dismiss an action without a court order by filing a notice of dismissal before the opposing party serves either an answer or a motion for summary judgment or a stipulation of dismissal signed by all parties who have appeared. Effect, unless the notice of stipulation states otherwise, the dismissal is without prejudice. So when getting a dismissal, you always want to try and ask for a with prejudice. With prejudice means that they can no longer take any action on this same claim against the same party. So this is how you get your double jeopardy clause in effect. So basically, they can't come again and charge you for that same offense again with prejudice. So it says, but if the plaintiff previously dismissed any federal or state court action based on or including the same claim, a notice of dismissal operates as an adjudication on the merits. So that they just said that in that same word, and I hate how, or I like how they say that we don't interpret law correctly. But I just read this to mean that they're going to grant you a with prejudice. So it's an adjudication. If adjudication is withheld, it means that you don't have a conviction. You're going to pay the sanctions, but there's no conviction based on that. So it says, by court order, an action may be dismissed at the plaintiff's request only by court order on terms that the court considers proper. If a defendant has pleaded a counterclaim before being served with the plaintiff's motion to dismiss, the action may be dismissed over the defendant's objection only if the counterclaim can remain pending for independent adjudication. Unless the order states otherwise, a dismissal under this paragraph 2 is without prejudice. So just speaking about that before. And then you have involuntary dismissal effect if the plaintiff fails to prosecute or to comply with these rules of court order. A defendant may move to dismiss the action or any claim against it. And let me see. Cost of previously dismissed action. If a plaintiff who previously dismissed the action in any court files an action based on or including the same claim against the same defendant, the court may order the plaintiff to pay all or part of the cost of that previous action and may stay proceedings until the plaintiff has complied. Alright, so I think that's it. I just wanted to give you an understanding of what is happening again when you're going into court, whether it's criminal or whether you're going in for a traffic ticket. It's all the same. They are all lawsuits. And basically what you're being sued for is a breach of contract. When you receive a traffic citation, they make you sign, and that sign and your signature is saying, they're telling you innocently, oh, it just says you promised to a peer. No, that is it's a contract, and when you start proceedings, you actually breach the terms of that contract, and you fall into default into I was about to say instantly, not instantly, eventually you will fall into default, and then they will win on their claim that they made. So you have to start taking these citations as what they are. They're lawsuits. Like I said, I just approved everything. There's a charging instrument, which is a commencing an action. That's under Rule 3 of the Federal Rules of Civil Procedure. And then there's a summons that is mailed out within, I guess, 2 weeks. They'll mail you a letter, which is a summons to come to court. If you fail to come to court, you may be arrested. So I'm just looking up because I have a few of them. I have them tacked on my wall right there. So you are dealing with a lawsuit, and you have to deal with it accordingly. So I guess I'm going to leave you on that note. What's the timing on it? So yeah, time is almost at an hour. I feel that's good enough. It's a good study guide for you to look into. If you have any questions, watch this video, someone shares it, don't hesitate to ask. I'll try to help you the best I can, no matter what state you're in. So thanks for watching, and I just wanted to get that off. Haven't done a video in a while. Really haven't had the desire, and not only that, I'm working on a lot of my own things, and I just don't have time to be distracted, or like I said, most times I feel like when you're trying to help people, it just goes, it's unappreciated. And for that matter, you know, I sacrifice a lot of my own earnings, money, and time away from my own research and my own document drafting. And like I said, I got a couple things going on. It's very important, very time intense, and I need to make sure I take care of that, because it's just sometimes there's no reward in trying to do a volunteer service to help people and care about people and be compassionate. I just think society is just a different place. So I appreciate you for watching, and thanks. Hope it helps you. If it does, you know, don't be afraid to let me know. Peace.